हेलो।
We request to switch off their mic. We request the participants to switch off their mic. I repeat, we request to switch off their mics. We request the participants to switch off their mic. I repeat, we request to switch off their mics.
क्या? हम अरे हम काम कर रहे हैं मम्मी, तुम्हें एक बात क्यों नहीं समझ में आती है? अरे हम काम कर रहे हैं मम्मी, तुम्हें एक बात क्यों नहीं समझ में आती?
So, hello everyone.
Good evening, sir.
Good evening, sir.
Good evening, sir.
Good evening, sir.
very warm welcome to everyone present here. It's an immense pleasure to welcome you all for the bootcamp organized by Interlegal World. I also welcome the speakers of this bootcamp. I welcome Advocate Rahul Tiwari sir, who is an assistant professor at Indore Institute of Law, specializing in cybercrime and economic offences, and the former associate at litigation firm Lamba and Lamba Gurugram, and the founder LNS Associate Gurugram. We also have Mr. Animesh Upadhyay sir, who is an advocate practicing in Lucknow High Court. He is the alumni of Dr. Ram Manohar Lohia National Law University, Lucknow, and is also the panel counsel for Uttar Pradesh State Warehousing Corporation. And
Shweta, you are not audible.
Oh,
Shweta, you are not audible.
hello.
Yes, you are audible.
Thank you. Thank you. So I'll start from the beginning. So a very warm welcome to everyone present here. So it is an immense pleasure to welcome you all for the bootcamp organized by Interlegal World. So I also welcome the speakers of this bootcamp. I welcome Advocate Rahul Tiwari sir, who is an assistant professor at Indore Institute of Law, specializing in cybercrime and economic offences, former associate at litigation firm Lamba and Lamba Gurugram, and the founder LNS Associate Gurugram. We also have Mr. Animesh Upadhyay sir, who is an advocate practicing in Lucknow High Court. He is the alumni of Dr. Ram Manohar Lohia National Law University, Lucknow, and is also the panel counsel for Uttar Pradesh State and Warehousing Corporation and Uttar Pradesh Khadi and Village Industries Board. His main area of practice includes criminal law, constitutional law, service laws, white-collar crimes, insolvency laws, and educational laws. So I welcome Rahul Tiwari sir and Animesh Upadhyay sir for this bootcamp. So this bootcamp is all about litigation. So litigation allows people to settle disputes that they have been unable to do on their own. So hence this bootcamp is on litigation, and it will help you to understand the risks, alternatives, the realities of major stages of litigation. So moreover, this bootcamp will help one to flourish and attain that in-depth legal knowledge related to litigation. So today the topics to be covered are the top concept of Cr.P.C and the Bare Act reading, the discussions on provisions to get an FI registered, the insight into Power of Police Warrant case and summon case, and the question and answer session for reply for the queries of day one. So I once again welcome to you to this bootcamp. So hope you have a wonderful and an informative session. So now I hand over the session to Rahul Tiwari sir.
Am I audible? Everyone?
Yes, sir, you're audible.
Am I audible?
Yes, sir, you're audible.
Sir, audible. But
Yes, sir.
Shweta, I'm not audible. You're not audible to me. That's
Oh.
the issue.
Can the other participants
Okay,
hear
just
me?
wait. I'll use the earphone. Maybe
Yes, ma'am.
because in my
No, sir, you are not audible, sir. Sorry, sir, you are not audible right now.
Sir, you
Sir,
were
before
previously
putting
audible,
headphone, you
but
were audible, now we are not.
indeed, sir. Yes, sir.
am I audible?
Yes, sir.
Give thumbs up in the chat box. Please let me know in the chat box because we have to start. Perfect. So, hello everyone. My name is Advocate Rahul Tiwari. I'm a practicing advocate in Gurugram District Court and as well as in Delhi High Court. And presently, I'm a visiting faculty in Indore Institute of Law. And there I met my friend and my colleague, Assistant Professor Amresh Patel sir, whose organization is this into legal world, which has launched the course, and I'm the faculty in the I'm one of the faculty in that course. Okay, and it's a 4 months holistic course in which I'll just request you to please go through the syllabus once. Okay, and this webinar is just more of an introductory type, and I just hope everyone has got their parent with them. Okay, so like I can see few students. So and about myself, I won't take much time. I'll just give a 2 minutes introduction. I completed my law in 2019 from Bharati Vidyapith Pune. After that, I worked in Babri Masjid demolition case as a research assistant to and Supreme Court advocate for 3 months. Then I completed my LLM. I have presented 25 research papers, and I'll request every one of you to please connect with me on LinkedIn. Okay, it's the best platform for professional networking. Trust me on that. And please do connect with me on LinkedIn. Just search Advocate Rahul Tiwari on Google. You'll get my LinkedIn ID over there. So, and after that, I practiced in Gurugram District Court as an associate in Lamba and Lamba. And then I opened my own firm, and presently I'm teaching in Indore Institute of Law also. And most of basically this webinar 2-hour session is more of we are going to introduce that how the course structure is going to work and how we have to actually read the criminal law. So fine, and first of all, let us make few rules for this webinar, and we'll make this webinar interesting. So one thing is there, I'll ask question, I'll pinpoint anyone, and that person has to answer. And one more thing, first of all, don't hesitate to answer. The worst will be that you will give wrong answer, right? It's okay. All of you are students, and all of you are supposed to make mistakes. It is expected from you to make mistakes. आप मेरे सामने गलती करके छोटा नहीं बनेंगे. Okay? So just if you really want to become an advocate, just throw this thing out of your mind that okay, what will be the other person will be thinking about me. Okay? This thing will not help you in litigation, especially in litigation, because the moment you will be defending a criminal in the court, obviously that kind of that thought has to go away from your mind. Okay, so just throw this thing out. Okay, so okay, fine, I'll start with Shweta Tiwari. Tell me, how do you read the law, especially the procedural law? What is your way of reading it? And it will just 2-3 minutes, and then I'll start teaching. Don't worry. It's just that it is just to just to grab your attention. Shweta, come on, answer. If you want to read Cr.P.C or CPC, how you are going to read it? Shweta, it's okay. Don't hesitate. Answer. It's not a webinar that where an advocate or a faculty will come and show off their knowledge and then just go. No. The purpose of this webinar is to make you understand the reality, and that is why I'm keeping this session in a more interactive manner. Okay, I think Shweta is a bit hesitant. Okay, Dheeraj Kumar Sharma, why don't you try?
Yes, sir, I can try. I'm audible, sir.
I think I'm not able to hear you now. Maybe if I have to hear you, I think I have to use the earphone. There's some issue with my MacBook actually.
Sir, when you put the earphone, you are nice, sir.
How do you read the procedural law? Suppose if you have to read, how will you read it?
Sir, actually, sir, I am first generation lawyer of my family, so I generally used to read their acts, sir. And after that, I make my own research on according to books and Google. Sir, you're not audible, sir, right now.
Are you a lawyer or a law student?
Sir, I'm law. Sorry, sir. I'm law student, sir.
please write chat box because there is some voice issue.
Sir, should I try?
Dheeraj, please write it down in the chat box. Okay, you are a law student. Okay, Dheeraj, please answer one more question. Are you from Bihar or UP?
I'm from Jharkhand, sir.
Dheeraj, it's okay.
I'm from Jharkhand, sir.
Chat box, chat box. Please mute yourself. Chat box. Okay, Jharkhand. Okay, Dheeraj, no issues. Even I'm from Bihar. Okay, no problem. So, now, that's great, Dheeraj. I'm from Motihari. Okay, so now, I would request you that how do we actually read it? Say, I'll tell you a problem. And that's why I have drafted few things that I'll tell you. There was one case. It was a check dishonor case. And when I was working, because what actually happened in that case, always remember few things. Just after this webinar, I'll request everyone of you to make this as a golden rule for yourself. First, if you want to read the actual law, please don't touch any book. Okay? No books. Only bare. And the best among the barracks is the universal edition. Okay? The yellow one. Okay? So please, you have to always refer to the barrack. That is the golden rule number one. And then second, the legal research is something which will help you throughout your career. You know, there was a great lawyer who once told me that lawyers never win their cases. Lawyers never win their cases by the argument done in the court, but they win their cases by the research done by the lawyer's chamber, by the lawyers in their chamber. Okay? So, I hope it makes you clear that these two things are extremely crucial. Barrack reading, the art of barrack reading, and the legal research. And now I'll tell you why. Like suppose, let's take an example of a tax lawyer. Okay? A person who is practicing as a tax advocate for 15 years. Okay? Means he started his practice in 2001 and he practiced in Delhi until 2016. Okay? And he was dealing with all kind of indirect taxation, not direct taxation, not in income tax. He was the indirect taxation, dealing with indirect, all the service tax and all. Now, what happens in 2016 is that we have a new law, which is GST. So, before that, now all the laws are repealed. Now we have a new law, which governs all the indirect taxation. So, will the lawyer will go and complain to his client that, oh, I'm really sorry. When I studied taxation during my CA, CS or law school time, that time we studied this, now we have a new law, I'm really sorry. No. The lawyer will go to the market, he'll buy a Bear Act, he'll take out time from his schedule, he will read the Bear Act, he will understand the technicalities, and obviously his experience of 15 years will help him in grasping the law in a more quicker manner. But that is the only way. Now, if it's a fresh graduate, 3 to 4 years of practice, an experienced advocate will take a month or two. A fresh graduate will take 3 to 4 months maximum to understand the technicalities, like what is the cascading effect, where the tax is collected, which are the states where the tax will be used, and all these things. Okay, so same is applied in the criminal law or in the litigation, or in fact, if you go to in any field. Now, if you go to the company law, same situation was there. Then again in 2016, we have a new law, which we call as Insolvency and Bankruptcy Code. Okay. Now we have a new tribunal, which is called NCLT. So my first advice, please take it in this manner that the first thing is that the most essential part is your direct reading, and second is your legal research. Why legal research and why direct reading is because see what actually happens when we read a book. Suppose let's take an example of bail. Now within 5 minutes I'll start with the direct reading part. I'll start teaching you. Now take an example. If you're reading a book, you're reading a chapter on bail, or you're reading a chapter on arrest, what will happen? You'll start reading that okay, for cognizable offense, the police can arrest a person without a warrant under these circumstances, and then you will read in a very in one line it will be mentioned that under section 41 the police is empowered. Under section 41 subclause A of Cr.P.C, the police is supposed to send the notice. Under section 46 search, 47 seizure, section 53 medical examination, section 53A test identification, section 54A test identification parade. But after when you get a flow, you know what happens that when you keep on reading for 15-20 minutes, you develop a flow. So what actually happens, the most important part is that when you read a book at the first instance without reading the bare, what will happen that you will take this as a story, mean law as a story, that okay, if a person commits a cognizable offense, the police can arrest without a warrant. A story. It will help you in getting good marks in your semester exams, but it will never help you in cracking first of all judicial service examination, and you will struggle a lot in your practice. Why? Because you have read a book which says a police can arrest without a warrant if a person commits a cognizable offense. Where it is mentioned? Maybe section 41 or section 41. But when you read section 41, we have 10 to 15 sub clauses over there. Okay? And that is the problem. See, and it is a human tendency. The person tends to, assume a lot of things in himself. Okay? Now suppose if it is a bailable warrant, the person goes to the magistrate court. If it's a non-bailable warrant, bailable warrant, a non-bailable warrant, where the punishment is less than 7 years, the person goes to the magistrate court again. Now, again it is a story. It is very good to read the book. When you read the book, you'll get good marks in your semester exam. But the 2 or 3 most crucial things in a law student's life or a fresh law graduate is their judicial service examination, their practice, or in fact their even the assistant prosecuting officer exam. You're never going to crack. Now why is that? See, suppose I'll give you an example. Suppose I write a book, okay? Maybe I might have some kind of my own propaganda. Maybe I'm a right winger. Maybe I'm a left winger. Okay? Maybe I have a certain kind of ideology, and it is a fact that when a person writes a book, his own ideology is reflected in its writing. Are you getting it? But when you read a bare act, the bare act is always without the emotion. It just tells you what is the law as it is. So first, read the bare act and then switch to the books for better understanding. And that is the only way, especially if you want to go in judiciary or if you want to excel in practice. I again repeat, there is no other formula. Okay? And that being a practicing advocate, I'm telling you this thing. There is no other way except read the bare act first and then switch to the books. Why? Because first when you read the bare act, your understanding is complete. Okay, your understanding is complete, and then when you go switch to the book, at least once your basic is clear, then when you read the book, then you actually get the in-depth knowledge. For example, please open everyone section 3 of Cr.P.C. I hope you have bare act along with you. I just request all of you to please open section 3, and don't worry when I am carrying the verdict, and I'll read section 3 along with you. So, what actually happened that luckily, because of my habit of writing so many research papers and presenting them, I did develop a habit how to effectively read the verdict. Don't worry. Indu Kumari Shaw, please write down in the chat section, you're in which year, Bachcha? That's what I'm going to teach you next 15-20 minutes. You're in which year? Third year. Section 3. Please open section 3. Now, what does it say? Construction of reference. In this code, it says what actually talks about, here it actually talks about the various codes. Now, when we talk about how many codes are there, so always remember, first of all, I'll give you a gist now. And why I'm referring to section number 3 is that there was a question which thankfully I read the verdict first, I was able to answer, otherwise it was a very easy question also and it was a very difficult question also, okay. Now, first understand the hierarchy of the court. The lowest court is Judicial Magistrate First Class. The power of Judicial Magistrate is that that JMFC can punish any person, can give punishment up to 3 years or a fine of 10,000 rupees. But just below that, there is also one court which is called Judicial Magistrate Second Class. Now, Judicial Magistrate Second Class can give the punishment up to 1 year. Okay. Now, Judicial Magistrate Second Class, Judicial Magistrate First Class, the power is defined in section 29. I'll write it down over here. Okay, in 29. Now, just above Judicial Magistrate First Class is the Chief Judicial Magistrate. Now, Chief Judicial Magistrate can give punishment up to 7 years. Okay, so we can up to 7 years. So I hope just give me a quick thumbs up that this is clear. Judicial Magistrate Second Class, First Class, and CJM. Clear, everyone? Give thumbs up. Okay, perfect. Now, always remember one thing, that CJM, Chief Judicial Magistrate, in every district there is only one CJM, which is in the civil side. See, now criminal side and the civil side. Urvashi, no problem. I will repeat. Deepa, I will repeat. I'll repeat. Don't worry. See, criminal side, Judicial Magistrate Second Class, Judicial Magistrate First Class. The power is defined in section 29. In civil side, they are called, if they handle civil case, they are called Civil Judge Junior Division. Their power is defined 29 bache. Urvashi ma'am, 29. Their power is defined by their pecuniary jurisdiction. Means pecuniary means the amount of money or the limit of the money for which they can take the case, like 10 lakhs, 50 lakhs, 2 crore. It varies from state to state. Okay. Now, but we'll stick to just because you don't get confused, I'll stick to Cr.P.C only. Judicial Magistrate Second Class, First Class, and then CJM. These courts are known as Magistrate Court. Please, if you are writing it down, write it down also. The Magistrate Court means JMFC Second Class, Judicial Magistrate Second Class, Judicial Magistrate First Class, and Chief Judicial Magistrate. Okay, these are the Magistrate Court. Now, above the Magistrate Court is the Sessions Court. First is the Assistant Session Judge, then after promotion it becomes Additional Sessions Judge, and then we have District and Sessions Judge. Now, the Sessions Court can give punishment more than 7 years. Okay, it can be punishment of 10 years, 15 years, life imprisonment, or death penalty. Okay, I'll repeat again. See, Magistrate Court, सबको समझ में आया ना? What is Magistrate Court? Judicial Magistrate Second Class, first class, and the Chief Judicial Magistrate. Okay. Now, always remember this thing, this part. Judicial Magistrate second class, first class, and CJM. The power, you know it now. 1 year, 3 years, and 7 years. Okay. Now, always remember one thing. Any crime where the punishment is less than 3 years, 90% of such problems, 90% of such crimes are bailable in nature. Now, what is bailable offense? Bailable offense are those where you can take the bail from the police officer. Okay? And non-bailable offenses are those where only magistrate can give you the bail. Got it? Now, so this is clear. Judicial Magistrate second class, first class, and then CJM. This is the Magistrate Court. Magistrate Court के ऊपर आ गया आपका Sessions Court. Court of Sessions जिसे हम कहते हैं. Okay? This is the Court of Sessions where the Court of Session can give you punishment of more than 7 years, which can be 10 years imprisonment, 20 years, 14 years, life imprisonment, or death penalty. Now, someone had asked in the chat section the art of effective bail reading. So now please open section number 3. Now, focus on these points very critically. What does it say? See, construction of reference, section 3, clause 1 says, in this code means Cr.P.C. Now understand where, on which words I'll put my emphasis on. And always remember one thing, the easiest way to read the Bail Act is that, when you read the Bail Act at the first instance, you will see the language is really tough. Okay? And the language is very confusing also. We don't actually enjoy reading Bail Act because of the language. It is really tough to comprehend, and especially for a common person, and especially for a law student. But when you start reading Bail Act for at least, I will not say it, this, in LinkedIn, this thing is trending, this 18 hours routine, but at least 20-25 minutes every day, read Bail Act. This will improve. This is the only way to improve, and being a law student, if you keep this in practice for 6 to 7 months, 8 months, you will automatically master it. Now, and the easiest way is that when you read the Bail Act, just underline, not with a pen, but with a pencil. See, in this code, like suppose something is written, credential info, Urvashi, that's what I'm going to explain. Don't worry, but just read. So, in Bail Act, you'll see after 4-5 words, you'll see always find a comma. You have seen, right? So, take this trick. This trick was taught by one of my teacher. Always take the comma as a full stop. Means, if in a 2-line sentence, 4 commas are used. If in a 2-line sentence, like 4 commas are used, take it as a 4 sentence. Means, split those 2 sentences in 4 small sentences and then read it. It will make you understand in a better way. In this code, subclause A, any reference without any qualifying word, see, again read it. Any reference, comma, means first sentence, without any, and don't worry, after section 3, I will read it out, section 437 also with you, okay, for you. So all these things will clear it out, and then arrest, and then not arrest, the FIR part, and then you'll understand, because when I'll give you example in 3 different sections, you will understand it. Now see this, any reference means any reference to the magistrate without any qualifying word. Means if there is qualifying word, means क्या हुआ, अगर कोई अलग से word दिया हुआ है, like suppose special magistrate, or if a court appoints a special judge for any heinous offense which has taken place, okay, for any fast track matter. Apart from that, to a magistrate, now again repeat, any reference take a pause, comma means pause. Without any qualifying words, pause, to a magistrate shall be construed unless the context otherwise requires. And what does it requires? First, means unless it means now, read it again. See, I'll tell you, this part is quite painful. I know it's painful but you have to give it a try. Now, just for the last time, read it again. What does it says? That any reference without any qualifying words to a magistrate shall be construed unless otherwise requires. It means any reference which is made for a magistrate, if there is no special reference or any qualifying words or any otherwise requires something else. Otherwise require means if there is some other conditions. Means अगर किसी स्पेशल परिस्थिति उसमें नहीं है तो हर वक्त in relation to an area outside metropolitan magistrate as reference to judicial magistrate. Now see this part again. इसका मतलब ये है, it means that because there must be a lot of students from South India also, so I cannot specifically, but okay, I'll do it in English and Hindi both. It means कि magistrate के लिए अगर कोई special qualifying word नहीं है तो हमेशा एक मेट्रोपॉलिटन एरिया के बाहर एक मैजिस्ट्रेट को जुडिशियल मैजिस्ट्रेट बोला जाएगा. और and the second part, what does it say? And in a metropolitan area the reference shall be metropolitan magistrate. Now understand this. Like suppose you clear Uttar Pradesh Judicial Service Examination and you clear Delhi Judicial Service Examination. Okay. Now, if you become, for example, in a small state, Unnao. Suppose you become a judge in Unnao. The first posting shall be judicial magistrate because it's not a metropolitan area. But because Delhi is a metropolitan area, all the areas which comes under any judge in Delhi is a metropolitan area. There, the judge is called what? Metropolitan magistrate. Okay? This is the basic difference. Means if a person, if it is a magistrate in a metropolitan area, section 3 subclause 1 just talks about the simple definition. Okay? Now the confusion will start in the B and the other part. First part, what does it say? It says if there is a magistrate in a metropolitan area, it is metropolitan magistrate. Outside metropolitan area, it is the judicial magistrate. This thing is clear. Now, a student asked that, sir, in section 29, we know the power of judicial magistrate second class, judicial magistrate first class also. But do we have judicial magistrate second class, or do we have metropolitan without any qualifying words? Means if there is any specific word, if it is mentioned like special magistrate, okay, or if the magistrate is appointed, the judge is appointed for any tribunal, not for any tribunal, for any commission or for inquiry commission. Apart from that, that's what it means. Okay. Now, a question was asked that do we have metropolitan magistrate second class? The answer was no. The metropolitan magistrate is equivalent to judicial magistrate first class also and judicial magistrate second class. How? Go to the next page and read section 3 again. Section 3, subclause 3 and point number D. Section 3, subclause 3, subclause D, sorry, clause 3 and subclause D. Means, what does it say? To any area which is included in metropolitan area as a reference to such metropolitan area, and any reference to a magistrate of first class or second class in relation to such area shall be construed as a reference to metropolitan magistrate magistrate exercising jurisdiction in such area. Okay, so now I hope this makes you clear that in metropolitan area, if a person is a metropolitan magistrate, then in his area, he exercise the power of both judicial magistrate first class and judicial magistrate second class. Okay, so now if someone asks you that why don't we have judicial magistrate second class in metropolitan area, so now you can answer. You will not answer that okay no, Rahul sir ne kaha tha section yes I'm teaching CRPC right now. Okay, so you will not say that Rahul sir ne kaha tha. No, you will just say first read section 3 clause 1 which defines judicial magistrate and magistrate, and then clause 3 subclause D which says the metropolitan magistrate in his area when exercise the power, he exercise the power first class magistrate or second class. Now when always remember this thing, when you find a word or in a bare act, it actually equates the term. Means although judicial magistrate first class and second class are not equal, but here what does it say? That even if it is first class magistrate or it's a second class magistrate, it does not matter. The metropolitan magistrate exercise the power of both the judges in his area, and that is why in section 29 we don't have any specification about metropolitan magistrate second class. We just have metropolitan magistrate. How many of you understood? Please give thumbs up, or else don't worry, in section 437 it will be further cleared. Or if you want me to repeat again, what I'll do is that I'll give a 1 minute recap. Isha, okay. No problem, Isha. Isha, see, when you read CRPC, don't worry. See, because we have just got a 1 hour slot now, so that's why I'm going a bit fast. But don't worry about the classes. And classes, all the classes will be of 2 to 2.5 hour duration. Okay, and it will be 50 hours classes a month, and the recording shall be provided till the end of the course. So even if you want to see, if you want to recall what did I read 2 months back, you can still have an access to the recordings. Okay, now see, section 3 clause 1 defines magistrate. Means if there is a magistrate in metropolitan area, if it is a magistrate in metropolitan area, it is called judicial magistrate. Sorry, if it is a magistrate outside metropolitan area, it is judicial magistrate, and in the metropolitan area, it is metropolitan magistrate. Now, in the non-metros, like suppose a person goes to like my hometown, Motihari. It's not a metropolitan area. Now in Motihari, I'll give you an example. Now in a Motihari, you will have judicial magistrate second class also, judicial magistrate first class also. Now section 29 of CRPC defines that in Motihari, if there is a judicial magistrate second class, he can give the punishment up to 1 year. The judicial magistrate first class in the Motihari, judicial magistrate first class in the Motihari can give punishment up to 3 years. But now, same judge, if he is in Patna, okay, it's a metropolitan area, there he becomes a metropolitan magistrate. But there he gives the punishment up to 3 years only, because in metropolitan area, according to section 3, clause 3, let's see, I'll write it down. Please see the comment section. Okay. Section 3, clause 3, subclause D, what does it say? That in metropolitan area, the metropolitan magistrate exercises the power of both judicial magistrate second class as well as first class. Now, always remember what did I told you in the morning, at the start, that in every district there is only one magistrate. Sorry, only one chief judicial magistrate. And chief judicial magistrate is the head of magistracy. What does it mean? Like suppose there is a district. Now a district has suppose 20 police stations. Okay. Now what will happen? This is something, and please I want to give one. It's a myth. We'll hear your seniors telling you that whatever you read in the law school does not comes in the practice. In practice, is everything is different. It is entirely false. Sorry, I disagree. I know it is an unpopular opinion. I know you wanted to hear that, whatever you're reading, and what you are reading in the books does not come. No, whatever you're reading in the books are applied in the court. Okay? We are not some loser seniors who are going to misguide you. That I'll be very honest with you. I'll not say that no, whatever you're studying in your law schools is not applicable in the court. In this course we are going to teach you something relevant which will help you out. No. Very honestly, Rahul Tiwari, I designed this course, okay? And we have a partnership with Into Legal because they have a very good outreach, and Into Legal World has got a very professional team. So that's why we have collaborated, and that's why we have launched the course. In this course, I'll tell you, the problem is, in law school, unfortunately, only the theories are taught. What is arrest? You read what is arrest, you write it down in your semester exam, and then you forget. But what I'm going to do is, the purpose of this course is to tell you that what is Cr.P.C and how whatever you read in the Cr.P.C, how it is applied in the court. Okay? I'm not going to say that no, whatever we study does not come in the law school. Then I'm sure that the judge will not give punishment for murder under section 376 of IPC. Because section 376 of IPC talks about rape. So a judge will always give punishment for murder under section 302 only. So whatever you are reading in your law school, that is what you'll see. Yes, I'm from New Law College. Whatever you read in the law school is what you see in the courts also. Okay? But the issue is, we are not taught how. So now I'll tell you how. This thing is clear. Now please write it down in an assignment for you, and I'll give you my email address. This is my email address, and please, I request every one of you to please connect with us on LinkedIn also. There I've got close to 26,000 followers. Okay, so now when we talk about the assignment, I was telling about the district. Like suppose in one district there are 20 police stations. So every police station covers certain area. So now entire district is divided in those 20 police stations. Now what will happen? Now suppose in that district there are 5 judicial magistrates. Okay, so what will happen? All those 5 judicial magistrates will have 4 to 5 police stations under him. So whatever FIR or a complaint is registered, that case goes to that magistrate. So that is how the hierarchy and the filing work of the court is done. But all the police station in the district, not the police station, sorry, I take back my word, but all the magistrate, all the JMFC are under CJM. So can we safely say that CJM is the head of magistracy? I'll write it down here. Magistracy, CJM. And in metropolitan area, it is called CMM, Chief Metropolitan Magistrate. Please find out that Supreme Court judgment which said that Chief Judicial Magistrate is the head of magistracy, and it has the duty to take care of the working of all the magistrate. I'm using the word magistrate. I didn't say sessions judge. Sorry. I said magistrate. It is the head of magistracy. Okay. I miss every district only has one overseas CJM. Okay. Here's the answer. So now another part. Please open. I hope now this part is clear that why we are doing this webinar. Okay. Now I hope you have in this last 45 minutes you have learned something very different, which was absolutely different from what you are reading up till now. Now please open section 437. Please open section 437 and please be very quick. Please be very quick and please open section 437. Now, what does it say? And that's why at the start I told you please keep a beret along with you. So it says, when bail may be taken in case of non-bailable offence, please underline the word may. The person had asked what is the effective way of reading beret reading. This is the way. Whenever you come across these words may or shall, always remember you have to underline it. May means the court has a discretion. The court can do, the court can refuse. Shall means the court has to do it. I'll give you another example. Just wait. Before section 437, let's read section 436 first. Because we have some provisos also, no? Please, I hope 436, section 436, read in what cases bail to be taken. It just says that in what cases a bail to be taken. First part, what does it say? First, when any person means it can be anyone, okay? And always remember, here in the beret, what is written? Person. Person means what? It can be a man and a woman. Okay? And now with the changing laws, trans person also. Person. Gender mention nahi hai yahan pe. So whatever it is written to the beret, you have to stick to it. So now when any person, again, is it talking another assignment? This any person, does it refer to the citizen or non-citizen? I've given you my email address. मेरे को आप आंसर बताइएगा email पे, ठीक है? When any person other than a person accused of non-bailable offence is arrested or detained, stop there. Or sorry, detained without warrant by an officer in charge of a police station, or है ना, वहीं पे stop हो जाएगी. और वापस से पढ़िए. When हर्ष रंजन प्लीज ईमेल पे भेजना था, कोई बात नहीं. When any person other than a person accused of non-bailable offence, मतलब कोई भी person जो एक accused है, उस person के अलावा जिसने एक non-bailable offence किया हुआ है, मतलब यहाँ किसकी बात कर रहा है? यहाँ उस इंसान की बात कर रहा है जिसने एक bailable offence की बात कर रहा है. वापस से इसको देखो, इसमें क्या हो ना कि थोड़ा सा उल्टा करके वर्ड यूज की जाती है, बट यू हैव टू प्रिपेयरिंग फॉर एंट्रेंस. आई हैव नो CRPC बुक. जस्ट बेयर एक्ट इज इनफ एंड इन द कोर्स एंटायर IPC constitution and international law is covered. So your IPC constitution international law, it will help you in your law entrance. Okay, now again come back to section 437. What does it say? It says when any person means हर वो इंसान, other than means उस इंसान के अलावा जिसने एक नॉन बेलेबल ऑफेंस किया हुआ है. तो उस इंसान के अलावा जिसने नॉन बेलेबल ऑफेंस किया है, मतलब when any person A की बात कर रहा है, other than a person B. B कौन है? जिसने नॉन बेलेबल ऑफेंस किया है. तो A कौन हुआ? जिसने बेलेबल ऑफेंस किया है. So it means what? Section 437 talks about bailable offense. Means जब भी आपको bailable offense में bail लेना है, it is section 437. So I hope you understand, because when you read in the barrack 1, 2, 3, 4, 5, it has 5 lines, but मैंने आपको second line पे ही stop करने को कहा. Now we will read again. When any person other than a person accused of a non-bailable offence is arrested or detained, इन दोनों में फर्क समझिए क्या? Arrest means FIR is lodged, और या फिर पुलिस वाले ने आपको अपनी आंख के सामने ऑफेंस करते हुए देखा तो आपको उठा के ले जा सकता है, फिर एफआईआर दर्ज करेगा, यू आर अरेस्टेड. डिटेन्ड का मतलब क्या है? फाइंड आउट द एग्जाम लैंडमार्क जजमेंट ऑन डिटेन एंड कस्टडी. द नेम, सॉरी, द वर्ड, केस लॉ का वो वर्ड है स्टार्ट्स विद डी. जो मेरे फॉर्मर स्टूडेंट्स हैं उनके लिए तो एक टेक वर्क होगा. ओके, डिटेन का मतलब क्या है? पुलिस ने आपको हिरासत में रख लिया बिना एफआईआर दर्ज किए. आप पुलिस एसएचओ की कुर्सी के सामने बैठे हुए, आपको कोई जाने नहीं दिया जा रहा, आप हो तो पुलिस स्टेशन पे. नो नो नो, नॉट एडीएम जबलपुर. एडीएम जबलपुर वाज वेरी लैंडमार्क जजमेंट, वो अलग केस हो गया एक. तो दैट वाज ADM Jabalpur had the reference of constitutional law also, not TK Basu Jay Prakash. अरे प्लीज कमेंट आंसर में मत दीजिए, ईमेल पे भेजिए. Not definitely not TK Basu. TK Basu talks about that rights of the arrested person. Person के अरेस्ट होने के बाद क्या राइट आते हैं, ठीक है? Now डिटेन आप समझ गए कि अरेस्ट हुआ है. अब अगर कोई इंसान जिसने एक बेलेबल ऑफेंस किया है वो अरेस्ट हो गया है या फिर डिटेन हुआ है, आगे पढ़िएगा. विदाउट अ वारंट मतलब क्या है? अगर आपने विदाउट अ वारंट का मतलब, इसमें विदाउट वारंट वर्ड यूज क्यों किया है? इसका मतलब why this is used is because usually in bailable offenses the police cannot arrest you directly. Okay, this will where it is written, how we'll do it in the course. Okay, the police can never arrest you directly, but the police for a bailable offence also can arrest you after taking the warrant of the magistrate. So now it is written like second essential criteria. If in a judiciary exams the question is that what are the essential criteria of section 436 Cr.P.C. आप तो वैसे ही कंफ्यूज होगे. क्यों? आपने किताब में केलकर की किताब में बस आपने वही कहानी पढ़ी थी कि if a person is arrested for a bailable offence the person has to be released. But how? Essential criteria, first essential criteria, the person has to have committed a bailable offence, the person is arrested or detained. Third, the person is arrested or detained without just wait, without warrant. Third essential criteria. For mains examination, though I will say barracks are enough, but please do your own research also. Please make your own notes also, because in mains examination what actually happened. I also know what is section 436. You also know what is section 436. Now if a question comes, whosoever will write a better answer will get more marks. It is not a semester examination, na? It is a competitive exam. So suppose in a 10-mark question I get 8. If you like, suppose you get 8, I got 6. You will get selected. So obviously, Divya, I would strictly advise you against just reading the books. But the criteria for the mains examination should be barrack reading, books, and then your own notes and research. Otherwise, sorry, I know a lot of my friends who are so talented, who are much more talented than me, and they are still stuck in that vicious cycle of pre-mains and interview, and they are not able to clear the exam. And I know personally they are far more better than me, but still, from 2019 they are still in that vicious circle. Chaya, barrack reading, books, and then your own research and notes. You have to make your own notes. Okay? Now see this. The person is arrested without a warrant and is prepared at any time in custody of such officer or at any stage of the proceedings, such court to give bail, full stop. Such court to give bail means fourth essential criteria. First, a person has committed a bailable offence, arrested. Third, he is arrested without a warrant and he is in custody of a police officer again, such person. Now see, first line में क्या था? बेरक के. First line में क्या था? Any person. अब वो any person fourth line में आते आते क्या हो गया? Such person. आपने देखा कि अगर कोई भी इंसान, अब इसको हिंदी में बहुत इजी लैंग्वेज में सुनते हैं, कोई भी इंसान जिसने बेलेबल ऑफेंस किया है, बिना वारंट के अरेस्ट हुआ है, कस्टडी में है, पुलिस उसे पेश करना चाहती है, तो वो इंसान, आप समझ गए? पहला क्या था? हाउ डिड वी स्टार्टेड? कोई भी इंसान जिसने बेलेबल ऑफेंस किया है, आते आते वो इंसान जो कस्टडी में है या फिर जो कोर्ट में पेश होगा, उस इंसान को कोर्ट बेल देगी ही देगी. कहाँ लिखा है? लास्ट लाइन में लिखा है, सच, प्लीज अंडरलाइन दिस थिंग, such person shall be released on bail. Means the court will give bail, and if it is a bailable offense. Okay, so now I hope you understand. Bailable offense है तो कोर्ट से बेल मिलेगी ही मिलेगी अगर पुलिस ने बेल नहीं दिया तो, वरना पुलिस बेल देगी अगर बेलेबल ऑफेंस है. फॉर एग्जांपल, there are two brothers. One person abused another person, defamation maybe, in front of a crowd. Two brothers, I said, not a person and a friend and his girlfriend. If you abuse a girl, it won't be section 499, it will be section 509, words or gesture used against a woman in intent to outrage her or not modesty. Okay, so that will be a different story altogether. And suppose anyone clicks a video of you, you will become viral and you will become star overnight, okay, in social media. So don't take that risk. So now I hope you this is section 436 is clear. Now read it. Second part. Divya, police custody is, a person is arrested, he is presented in front of a magistrate, the police asks for police custody. Make it a note, किसी भी कीमत पे 15 दिन से ज्यादा पुलिस कस्टडी कभी नहीं मिलती. Means police custody is what? The police lockup. After that, the person, if the bail is given, is free. If the bail is denied, the person is sent to central jail. That is your judicial custody. Bailable and gets bailed by the police, then is it enough? Yes, Lavkesh, that is enough. Okay? Now, come to the proviso. Proviso means, as committed and gets, someone challenge the bail? Yes, you can challenge the bail, but you have to prove that it was not a bailable offense, but a non-bailable offense. Okay? Yes, section 167. And for section 167, if you would go through the course brochure, Rita, if you go to the course brochure, I have kept around 4 to 5 hours classes in section 167. Why? Because recently, what actually used to happen, that remand period, what is the remand period? That till the time the person allows, the court allows to keep a person in the jail or not. So now what actually happens, suppose a person is arrested, it is 6:05, 9 p.m. Okay? 9th September. So if a person is arrested at 6 p.m. on 9th September, okay, and the person is presented in front of the magistrate in around at exact 9 p.m. on 10th September. So what is the time? 15 hours. So will this time be calculated in the remand period or not? Recently the Supreme Court has referred the issue to the higher bench. So now this is the dicey part. As of now, Roshi, it is the dicey part, because this part, usually what used to happen that it became the discretion of the court whether to calculate it or not. There were judges who used to calculate these 15 hours also in the remand period. There were cases that this part was also read it out. Section 354D. If I can recollect, it's not a bailable offense. So if it's not a bailable offense, the person will get bail. Because the punishment is less than 7 years, the person will get bail under section 437 Cr.P.C. Okay, but Srishti, just give me 2 minutes. I am reaching section 437 in 2 to 3 minutes. Okay, now section 436 of CRPC. This part is clear. You have understood this thing. Now, without any updates, a law related to bail is specifically designed. Can you tell, sir, there are recent updates about law related to bail be specifically designed. Uh, I cannot comment on such updates unless and until the bill is presented in the parliament. Obviously, the bail part is that we have a lot of under trial prisoners in India, and the legal aid part is not. I don't think it's not functioning up to the mark. So that is why it is given the focus is given by many jurists and the retired judges also. But unless and until any specific act is brought in the parliament or in the lower house of any state legislature, I don't think I am the right person to comment on it. Okay, now read this part. Provided that such officer or court, if he or it thinks, he means officer. Now please don't ask that, okay, why not he or she? Okay, because the CRPC was made in 19. Okay, third assignment. If someone gives, I'll give Netflix subscription. I'll give that person Netflix subscription for 1 week. That why only he is written, why she is also not given. Okay. No, Lokesh, I'm running out of time, bache, because there will be a second speaker. I cannot keep that second speaker waiting. Okay. Now, provided that such officer he likha hai or court uske liye it likha hai, thinks fit, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail of such person, discharge him of executing bail without surety for his appearance hereinafter forward. Means, yahan pe, can you see this part, Animesh sir, regarding the course? It's not Animesh, it's Amresh sir is here and he's waiting to start his lecture. Okay, don't worry, Aditi. What we will do is section 436, section 437, okay, and the arrest part we will continue in the next lecture. So I'll request everyone that please, and that's what I said, commit all the assignment. Lokesh, don't worry, now we'll have another opportunity to submit tomorrow. And Aditi, one more thing. Aditi, can you please open your, Aditi Chauhan, can you please open
Yes,
your
sir.
video? Or else can you please unmute yourself at least?
Yes, sir. Yes, sir. Yes, sir. You are not audible when you are using the headphones, sir.
Now, as I guess it's Animesh sir is here, so let him take the lecture.
Sir, it is
And
Educate
if
Animesh.
you have any doubt, my dear friends, today because it was the first day of the boot camp, okay, that's why I have to apologize. I cannot take doubt as of now. I'll write it on my email address again. If you have any doubt, send your doubts and assignment on this email address. That deadline for submitting the assignment is today itself. Tomorrow I'll finish the remaining part, and obviously please connect on LinkedIn also. Okay. You can find me in Indore Institute of Law with the reference and okay. Please do connect on LinkedIn, and all the doubts we will take. So Aditi, I don't think after 8 p.m. after the Animesh sir is finish this lecture, I'll be able to continue. I'll be able to rejoin it because I have some commitment right now. Okay, Aditi?
Okay, sir. Thank you, sir.
Comment box. Okay, we'll meet directly tomorrow.
Yes, sir. Sure, sir.
In the comment box, I can't hear
Sure,
you.
sir.
Okay. Thank you. So everyone, thank you everyone for being such a nice audience, and I hope Aditi, please do share the course detail with the participants. Okay. And thank you very much. We'll meet we'll meet tomorrow. We'll read the entire the bail, arrest, and FIR tomorrow. Okay, and just okay. So thank you everyone. Yeah.
Thank you so much, sir, for all the valuable information you have given. It was a pleasure listening to you, and I hand over the session to Animesh Upadhyay, sir, right now.
Just give me 1 second. Uh, Hello everyone. I hope all of you are doing fine. So first of all, I'm very grateful to Into Legal World for inviting me to take this session. And the topic which I have been assigned is power of police to arrest someone and the acts that govern police powers and duties, and also to give a detailed elaboration on difference between warrant and summon. So I was there in the. I heard some part of the lecture that was delivered by Mr. Rahul Tiwari sir, and I hope that uh, most of things are covered by him. That from the stage when an FIR gets registered, then how the investigation starts, and how CRPC works, what is the intent, the context. So, this arrest basically means to deprive a person of his liberty by legal authority. So, there's this landmark judgment also on this point where arrest has been defined in Supreme Court judgment, that is R. Shari versus State of Uttar Pradesh. Am I audible now? One second. Am I audible? Aditi,
Yes, sir, you
can
are
anyone
audible.
confirm that?
Yes, sir.
Now you are audible.
Okay. So there's this landmark judgment of Supreme Court, R. Shari versus State of Uttar Pradesh, where Supreme Court said that the act of being taken into custody to be formally charged with a crime is known as arrest. So in IPC, if you all might have studied that what why the arrest is, why a person is given punishment, or the same goes with the arrest also. Arrest acts as a puts a deterrent effect so that the further crime cannot be committed. So reasons for arrest are like to free for securing free and fair trial, to remove chances of tampering with the evidence. So basically, if a person who has committed offense, and if the trial has to take place, and the offense and the person is of such nature, it's R. Chari versus State of UP. So if there are chances that the particular person, if the police has apprehension that the particular person might tamper with the evidences during the investigation and during the trial, so that's why the arrest is made to secure the fair and free trial. Now, secondly, to secure the presence of the accused during trial. So once a person is arrested, then sir might have told you about how the trial goes on. Like once the FIR is registered, then the person is arrested. Then he is produced before the magistrate within 24 hours of after the arrest, and then after the sections 167 of Cr.P.C defines investigation. Then the investigation takes place, and after this whole process is done, charge sheet gets filed under section 173 Cr.P.C. After that, the stage of framing of charges takes into play. Take play of charges, the magistrate will commence the trial in particular sections under which the person is charge sheeted or as the magistrate deems it. So, so that the person who has been arrested, the arrest gives the guarantee that the person will be present at the time of the trial whenever he is directed by the court to appear for the trial. One of the reasons for making arrest is, thirdly, to obtain the correct name, address and details of the accused. And as I said earlier also, it is used as a preventive measure and to remove hindrances in an investigation by the police. Now, there is a one thing which I want all of you to note, that is that there is a difference between custody and an arrest. See, every custody does not need arrest, but every arrest does need custody. Meaning thereby that mere keeping a person on surveillance can be called that he is in custody, he is under custody. But arrest is different, and every arrest needs custody. I hope you all are getting what I am trying to say. And if anyone has
can you please
questions
repeat?
till now, yeah. So see, there is a major difference between custody and arrest. All right. In custody, there is no need for arrest, and in arrest, there is a need for custody. Like, for example, a person has been kept on surveillance by police. Now, the person A is said to be in the police custody since he is being constantly monitored by the police officials. All right. And in arrest, obviously, it's logical that custody is important to keep that person, to secure the presence of that person. Till now, if any confusion, if there is any confusion or any question someone wants to ask. So, okay, I guess then we can proceed further. So types of arrest in Code of Criminal Procedure. Arrest without a warrant. So there are 4 types of arrest. All right. Arrest without a warrant, that is defined in our section 41 and section 42 of Cr.P.C. Arrest with a warrant. Arrest made by a private person, defined under section 43, and arrest by magistrate, section 44. So what section 41 says, going barely reading section 41, when police may arrest without warrant. So there are reasons given, or there are situations given when a police officer can arrest a person without warrant. So, not one second. All right, I'll mention it. So, there are 9 situations given under section 41 of Cr.P.C. where a police officer can arrest without a warrant are as follows. Like, any person actually concerned or is reasonably suspected to be concerned in a cognizable offense. Now, if anyone can let me know what is the difference between a cognizable offense or a non-cognizable offense, please.
Sir, cognizable are serious offences for which we do not need warrant to arrest. And in non-cognizable offences, a warrant is required.
Okay. Yeah. So, uh, so first situation is that any person actually concerned or reasonably suspected to be concerned in a cognizable offense. So, in case of cognizable offense, if a police officer apprehends that this person is a suspect and has committed an offense, so there's no need for a warrant in that case. Now, second situation. Third, a person who is a proclaimed offender. So, proclaimed offender. Now, this issue of proclamation is defined in section 82 and 83 of Cr.P.C. And a proclaimed offender is one who is a habitual offender. So, yeah, I hope there is no voice breaking, or am I audible or not? All right. So a person who is a proclaimed offender. So, for example, if a person has committed many cases of similar nature and there is a long criminal history in his name, therefore that person is said to be a proclaimed offender. And if a police officer is suspicious, apprehends that this particular person only might have committed this particular crime, then he can arrest him or her without warrant. Now, any person who is in the possession of property reasonably suspected to be stolen and who may be reasonably suspected to have committed the offense with reference to such property. Fifth, any person obstructing the police officer in the discharge of his official duty or who has escaped from lawful custody. Uh, Six, a person who is a deserter from any of the armed forces of the Union. Seven, any person who is concerned or who is reasonably suspected to be concerned with any committed outside of India, if it would have been committed in India, would be punishable as an offense and would have been liable to be apprehended or detained in custody of India. Now, eight, any person who is released is convicted committing a breach of any rule made under section 356 clause 5 of Cr.P.C. Now, what does 350 open 356 clause 5? Now, what does section 356 say? Can anyone read it out for me? Hello. Am I audible, Aditi? Yeah,
Yes, sir, you're audible.
yes, Cr.P.C.
Hello, good evening, sir.
Good evening.
Yes, sir, section 356.
Yes, 356 clause 5.
Yes, sir, section 356, clause 5. The state government may, by notification, make rules to carry out the provisions of this section relating to the notification of residence or change of or absence from residence by release convicts.
actually there's a network issue on my end. I guess that's why the voice breaking and all this taking place. So ninth situation, any person for whose arrest requisition has been received from another police officer and is authorized to arrest him without a warrant. So these are all situations when a person can be arrested by a police official without a warrant. Now, coming to the topic that is arrest with warrant. An arrest warrant is issued by a magistrate, and in cognizable cases, arrest warrant is not required, as discussed earlier also. During the course of an investigation of cognizable offences, police officers can arrest without warrant, but in non-cognizable cases, the arrest can only be made once the warrant is issued by the magistrate. In non-cognizable cases, it is required to be analyzed whether the case is a summon case or a warrant case. Now, it is most important for a police officer to, before making an arrest, whether it is a summon case or a warrant case. Now, the general rule, which is that in summon cases, first the summon is issued to the accused to require his attendance in court, and only on failure to comply with the same, the warrant is issued. I hope this is clear to everyone, or shall I repeat it?
Repeat it, sir.
Okay. So before making an arrest, or before, see, there is this two different things, that there is a summon case and a warrant case. Okay. So the general rule which is needed to be followed is that in summons case, first the summon is issued to the accused to require his attendance in court, and only on failure to comply with summon, a warrant is issued. So for example, a magistrate orders a particular person to and releases a summon, passes a summoning order with regards to the presence of सर गया does not all right. Hello.
Yes, sir. Now you're audible, sir.
Okay, okay. So I was saying that there is this general rule in summon cases. If so I will tell you with an example. So see, if a magistrate passes an order for a particular person and passes a summoning order to appear on one particular date, and the concerned person does not appear and does not comply with the summoning order, then the magistrate passes a warrant, issues a warrant, and then the arrest is made. And what is a warrant case? In warrant case, warrant would directly issued to ensure the presence of the accused in a court of law. Now, please be interactive, at least let me know if you are facing any problem so that I can solve the same.
there's a small technical issue and it will be resolved in few minutes. Also, when sir is asking something, I request all the participants to respond. So in this meantime, I'd like to introduce you to our course, which is a course on litigation. So as you have seen on that group, we have already given a small brochure on litigation course. So as you can see, this bootcamp is also related to litigation. So this certification course allows people to settle disputes and where they had been unable to do on their own. So this course can help you to understand the risks and alternatives and the realities of major stages of litigation. And also in this course, by working through case studies, you will understand the litigation comprehensively. And it will also help one flourish and attain an in-depth legal knowledge related to litigation. So this, from this course, it offers a solid grounding on litigation course, and it covers laws including Cr.P.C and other special statutes. Also, it has, it also talks about many case laws and recent developments, etc. And so talking about the course details, we can see we have live classes for 200 hours, and there's also recorded lectures for 100 hours, and the course length is of 4 months. So you can get more information regarding the same course on which the brochure and the poster has been sent in the group. So for when you join for this course, you can get the online classes will be on weekends evening for 2 hours, which is very comfortable for each and every person here. And the recordings for lectures will be provided as well. And a very important thing, that is certification of participants to all the students on completion of this course will be given. And also the certificate of merit on 60% attendance and 50% assignment submission will be also given. And there is a confirmed internship for meritorious students under senior advocates in litigation firms. And in case a landmark judgment is passed by Supreme Court, that shall be discussed as a part of the syllabus. So basically, the main idea of this course is to equip students with fundamentals of criminal, civil, and constitutional laws. And this course is a combination of practical and execution of interpretation of various statutes of law. So the course outline has been shared with you in the group. So I hope everyone can join this. And talking about faculty, as I have already mentioned about Advocate Rahul Tiwari sir, and we also have Advocate Prakash Pandey sir, and we also have Animesh Patel sir, who are the faculties of this course. So for more information, you can contact us, and also you can follow us on our LinkedIn page. So I hope each and every person join for this course, because this course is very informative, and hope this session also, for this session actually there's small internet glitch here. So I guess sir will be right back after a few minutes. If there's any problems or any doubts regarding the course, let me know, because I can clear the doubts for you guys. Because also the payment details, everything is written in the brochure itself. If you need a QR code or registration, the form, you can let me know. I can share it in the chat box as well.
arrest. Like, so, yeah. So, in under the topic arrest without warrant, I want all of you to note these two judgments. Bhavu Jivaji versus Malji Dayal. And this is your today's assignment also. That please read this case thoroughly. In this case, it was held that circumstances laid down in section 41 of Cr.P.C. They are not exhaustive in nature. So there are various other provisions in laws which confer powers on police officer. Okay, 1 second. Bhavu.
क्या कर रहे हैं?
And in this case, it was held that in this case, that circumstances laid down in section 41 of Cr.P.C. they are not exhaustive in nature. So the situations which I told you, they are not hard. These are not hard and fast rule. Now coming to the judgment of Animesh Kumar versus Bihar. Now down. Now in Animesh Kumar versus State of Bihar, arrest guidelines were laid down by the Supreme Court. So the Supreme Court in this, a person was accused of Section 498A, and the Supreme Court laid down that in cases where if the offense is of such nature that the punishment is less than 7 years, then the police officer need not arrest him quickly. He has to first serve a notice under Section 41A of Cr.P.C. Section 41A of Cr.P.C. states that a police officer should first issue a notice to the person accused of an offense less than 7 years, and basically the notice is served upon the person to secure for putting his presence before the police officer so that the investigation gets carried on. So Animesh Kumar versus State of Bihar. Please go through this judgment thoroughly. It's a landmark judgment on the arrest guidelines that were laid by the Supreme Court. Now coming on section 43 of Cr.P.C. So section 43 of Cr.P.C. states that any private person may arrest without warrant any person if a person commits a non-bailable and cognizable offense his presence and the person is a proclaimed offender. Till now, if any one of you has any confusion or any question to ask, please let me know. It's section 43 CRPC. Urvashi. Arrest made by private person. Alright. Now, arrest by magistrate. Any magistrate. So first of all, arrest by magistrate is defined in the section 44. So it says that if an offense is committed in his or her presence, the same situations. Okay. So section 43 of CRPC, Chaya, it states that a person can be arrested by the private person without a warrant in two situations. If the particular person commits a non-bailable and cognizable offense in his presence, or the person is a proclaimed offender. Alright, you got it? Chaya? Okay. Now coming to section 44, which states arrest by magistrate. Any magistrate, either it's executive or judicial magistrate, may arrest or can order any other person to make arrest if an offense is committed in his or her presence and the offense is in his local jurisdiction. So all of you are, I guess all of you are acquainted with the term jurisdiction. All right. So if a person commits the particular crime or in the presence of any executive magistrate or judicial magistrate, am I audible? Okay.
Yes,
So if
sir.
a person commits an offense, if a person commits an offense in the presence of judicial or executive magistrate, then arrest warrant can be issued by that by either of the two magistrates, and but the condition which is mandatory is that the particular offense should have been committed within his local jurisdiction. Now, there is an exception to this general rule of arrest, and that is section 42 of CRPC. Can anyone read out section 42 of CRPC? Please volunteer. I'll call out name.
I'll read out. Arrest
Okay,
on
okay.
refusal to give name and residence. Clause 1. When any person who, in the presence of a police officer, has committed or has been accused of committing a non-cognizable offense, refuses on demand of such officer to give his name and residence or give a name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained.
Yes. So now in this case, a police officer can arrest a person. So warrant is needed when a person commits a cognizable offense. Now what section 42 says is that a person can be arrested by the police official without a warrant if if he has committed the non-cognizable offense, but he is not basically cooperating with the police. Like he is not providing his credentials like address, name, etc. So in that case as well, a person can be arrested without warrant by the police official. Now there are laws on handcuffing as well, and there is this major, there is this landmark judgment on the law of handcuffing. So section 49 CRPC, it has been stated in under section 49 of CRPC that no unnecessary restraint should be used in making and securing the arrest of any person. Now, in landmark judgment of Prem Shankar Shukla versus Delhi administration, let me write it down. So these two are the landmark judgments, and in these, basically, the Supreme Court held that Article 21 forbids. See, what does Article 21 says? It says that every person has a right to live with liberty, right to dignity. Okay, so it was held by the Supreme Court. It was observed basically that Article 21 forbids deprivation of personal liberty except in accordance with the procedure established by law and curtailment of personal liberty to such an extent as to be a negation that it would constitute deprivation. So basically, if you have read the Maneka Gandhi versus Union of India, so in Maneka Gandhi also, it was said that if a person is following the due process, if it is said by the due process of law that particular act has to be done, and in that case, if if the liberty is snatched, then that will be constitutional and will not be violative of Article 21. So go through these judgments, because see, so now concluding the arrest part, when an arrest is made, okay, a person's liberty is snatched away from him, and for restoration of the same, he applies for the bail in court of law. Now, bail is another topic that we'll discuss, or I guess it might have been discussed in the earlier lecture. So, coming to the topic, act that regulates police power and duties. So, the act that regulates police power is Indian Police Act 1861. Please write it down. Now these were so we have till now discussed what is arrest, how arrest can be made, what are the situations, when can the arrest made without warrant, when it can be made with warrant, what are the essentials, all right, and what is a warrant case, summon case, why arrest is done. All right. So in that part, if anyone has any question or has any confusion, please let me know so that I can clear the same. All right. Then proceeding further. So and execute all orders and warrants lawfully issued to him by any competent authority to collect and communicate intelligence affecting the public peace. So basically, Section 23 requires every police officer to execute all orders and warrants. So if a warrant is issued by the magistrate, then it is the duty of that police official to execute that warrant properly, and there is no failure in compliance of the same. All right, and also to if there is any apprehension that public peace might be affected by if the particular act is committed, or there are any chances in future that this particular act, if happened, can disturb the public order, then it is the duty of the police officer to prevent that act from happening. All right. To detect and bring offences to justice and to apprehend all persons whom he is legally authorized to apprehend. So basically, if we go through the provisions of Cr.P.C, like Section 41, the situations that are enumerated in Section 41 of Cr.P.C and this Section 23, we can see that both are in consonance. So basically, if the police officer has an apprehension that particular person should be arrested with in case of cognizable offences, all right, then that police officer is fully authorized to do the same. And Indian Police Act basically was enacted with the purpose to provide guidelines to the police officials to basically how the police officials should act. Now, the term that is the term in Section 41 that police officer may arrest a person on apprehension has been interpreted many a times by the court. Uh, 1 second. Indian Police Act defines the powers and responsibilities of the police officer. So I was telling you all that if you read the section 41, the provision for arrest. So police, please specify which link you are talking about. Okay. So the term police may arrest has been interpreted many a times by the Supreme Court in number of judgments, which I'll write it down. And in those judgments, it has been stated many a times by the court that the police officials the term may arrest has been given the narrow approach, and so the narrow approach prohibits the police officers from arbitrary arrests, like made in Animesh versus State of Bihar. So there were cases rising in Madhya Pradesh also, and the Madhya Pradesh High Court recently directed the DGP of the state to look into this matter, because the arrest guidelines which were enumerated by the Supreme Court in Animesh versus State of Bihar were not followed properly. So the Madhya Pradesh High Court took cognizance of the matter and directed the DGP. So every state is so the principal act is Indian Police Act 1861, and every state has its own regulations, like the Uttar Pradesh Police Regulations, Madhya Pradesh Police Regulations. So till 2015, after the police reforms, the 17 states have notified that they have their separate regulations. So I guess we are out of time now. So if till now, if anyone has any confusion or question, please let me know, and you can communicate your queries to Aditi as well, so that I can address them properly. And if there's anything which you have missed out, like the judgments or the sections, so let me know the same, so that I can address it properly, or let Aditi know. Yeah. Thank you.
Thank you so much, sir, for all the information you have given us, and it's so valuable. So I thank all the participants who attended this boot camp, and hoping that everyone present here has got many valuable information. So as a formal vote of thanks, I like to thank the speakers, Advocate Rahul Tiwari sir and Animesh Upadhyay sir, who has taken time from their busy schedule and giving us valuable information. I also express my gratitude towards everybody, and we shall meet you tomorrow. Thank you so much for joining us.